Good morning, Prof. Our group's title is Application of the Plea and Penalty Leniency System for Corporate Crimes in China. My name is Liu Ziliang. Here are our group members. The contents is about 4 parts: abstract, introduction, literature review, findings, and recommendations. First, abstract. Introduction. Article 15 was added to China's criminal procedure law when it was revised in 2018, which reads, if a criminal suspect or defendant voluntarily and truthfully confesses his or her crime, admits the facts of the alleged crime, and is willing to accept punishment, he or she may be treated leniently by the law. This marks the formalization of the leniency system in pleading guilty and accepting punishment into law. Problem statement. However, at present, Chinese laws and regulations do not contain specific provisions on the leniency of guilty pleas and penalties for enterprises. In practice, the standards applied by prosecutorial organs around the country in using the system of leniency of guilty pleas and penalties for corporate crimes are inconsistent. Objective. The purpose of this paper is to analyze the significance and problems of applying the system of leniency of guilty plea to enterprises, to put forward measures to improve the system. Methodology. This paper adopts the method of qualitative analysis, using literature analysis, comparative analysis, and case analysis to analyze the collected cases and journals. Findings. The criteria for enterprises to plead guilty and admit punishment are not clear, and the leniency for enterprises is not strong enough. Recommendations. Seize the opportunity of the upcoming fourth revision of the criminal procedure law to amend the law to clarify the criteria for enterprises to plead guilty and admit punishment, and to increase the leniency of enterprises after pleading guilty and admitting punishment, and combine the plea bargaining leniency system with the enterprise criminal compliance system. The second part, introduction. In practice, although there are no laws and regulations that stipulate how enterprises can plead guilty and accept punishment leniently, there are some policy documents and articles that support the application of the system to enterprises. For example, this article requires that for enterprises and institutions suspected of committing a crime during the epidemic, the system of leniency in pleading guilty and accepting punishment is applied to cases in which a voluntary guilty plea is made, understanding is obtained, and the social harm is not significant. In addition, the application of the plea bargaining system in corporate crime is also reflected in China's judicial practice. This is an example. However, the vast majority of corporate plea bargaining cases in practice are still handled mainly concerning natural persons pleading guilty, mainly because China's current legal system does not explicitly provide for how corporations and apply the leniency system for plea bargaining. The third part, literature review. First, the value of establishing a corporate plea and penalty leniency system in China. First, wide range of applicable cases and low economic costs compared to the criminal compliance system. Second, enriching the procuratorial's treatment of enterprises suspected crimes in the review and prosecution segment. Third, reducing the difficulty of case handling authorities in dealing with enterprises suspected of committing crimes. Fourth, protecting the development of the private economic. 5. Conformity with the international trends and avoidance of adverse social impacts. The purpose of analyzing the above literature is to demonstrate the value of applying a lenient belief system to businesses from multiple perspectives. Second, problems encountered in applying the leniency of beliefs and penalties to enterprises in China. First, ambiguous standards for corporate guilty pleas. Second, ambiguous standards for enterprises to admit punishment. Third, the mere leniency of punishment is not conducive to motivating enterprises to plead guilty and accept punishment. Four, unclear relationship between corporate plea and penalty leniency system and corporate criminal compliance system. Although previous literature has analyzed the problems encountered by enterprises in applying the leniency system for guilty pleas and proposed measures to deal with them, the measures proposed are not specific and detailed enough, and this paper aims to fill this gap by proposing more specific and detailed measures to deal with them. Four, findings and recommendations. First, clarify the criteria for enterprises to plead guilty. It is recommended that a criteria for admission of guilty be added to the law amendment. That is, two conditions need to be met at the same time. The first condition is that the board of directors or the general meeting of shareholders of the enterprise, acting on behalf of the collective will of the enterprise, make a lawful resolution recognizing that the enterprise has committed a criminal act, which is an important manifestation of the enterprise's voluntary admission of guilty. The second condition is that the enterprise's admission of guilty requires both recognition of the facts and admission of guilty. Second, clear standards for enterprises to recognize punishment. The enterprise suspected for committing a crime after active reparation, compensation for the victims is an important performance of the acceptance of punishment. In addition, also need to consider the following factors. First, the enterprise must need to procuratory to put forward an internal recertification plan. Secondly, if the enterprise pollution of the victim environment type of crime, the enterprise's admit punishment content is more specific. The enterprise needs to undertake economical restoration tasks. Third, enriching corporate leniency after a guilty plea. First, procedural prospect. Adopt lenient coercive measures. Second, the means of investigation are lenient. Second, entity prospect. Amend the law to design rules on sentence reduction for corporate crimes. Third, combine the plea bargaining leniency system with the enterprise criminal compliance system. This is my group's article. Thanks for listening.